Senator Galbraith.
I would conclude, Madam President, by saying that certainly if we were to rely on the equal protections of the Constitution and they were enforced, then there would be no need for ERA. And if ERA passes, I'm sure it will pass, not only here, but I'm sure it's going to pass when it goes to the people of the state. And what it's going to say is that if we don't, in good faith, follow through, that even with the passage of ERA, that there will be no progress. But as I alluded to before, I have faith not only in this country, but in the Constitution. I recall historically back in 1932, I believe it was 32, when there was a change in Social Security, that the states quickened to fall into line. And I think these disabilities, if I can term them that, the problem areas that the opponents of ERA are talking about, brings to mind a key responsibility for the state to take those matters into consideration. And I think they will, because I have faith that the state legislature can do their job. Thank you, Madam President.
Senator Gold.
Thank you. Madam President, I have to respond to some of the comments of Senator Schermerhorn. Firstly, Senator, you referred to insurance, and my understanding is that you're quite an expert on insurance. And I can't believe that you, in your day-to-day activities in that business, don't realize that classifications are made by the insurance companies and permitted by law. That young people and old people do not pay the same premium. That classifications are made in all kinds of insurance. And that none of our constitutional limitations on discrimination or statutory restrictions stop that. I also have to refer to the conversations with your daughter, because Senator Padovan.
Information, Madam President. Was there a speaking order that you had?
Senator Padovan, it was the chair's understanding that Senator Gold was going to answer a question of Senator Schermerhorn's, and you are the first speaker on the order, Senator.
You refer to your daughter and you refer to the draft on Social Security, and I'm not going to belabor it, Senator, because I think that everybody in the chamber, and I hope you too, understand that there is a federal constitution and a state constitution, and the only way you can amend the federal constitution is by a certain number of states agreeing to language, but that has nothing to do with the issue before us today. Because if we pass an equal rights amendment to our Constitution and 38 other states, or as many as they want, do it, they can only affect their own state and their own state constitution. What you are talking about is a different issue, and that's the federal Constitution and the federal ERA. So let's not confuse that. You talked about privileges and rights. Senator, I want people to have privileges, and I want them to have rights, but I want them to be justified and not unjustified, based upon irrelevant classifications of people. And one of those irrelevancies is sex. And you concern yourself with sexual conduct between adults and minors. Well, you yourself said it, adults and minors. There's no sex differentiation there. And any child of any sex should be protected against advances by any adult of any sex. And nothing's going to change there. And statutory rape is again a matter of age. And sure, young people should be protected by our laws against advances that they do not understand and forced upon them by older people. You mentioned, I think quite unfairly, the fact that there was a group with a certain sexual persuasion which is in favor of ERA. But Senator,
just a moment, Senator. Why do you rise?
I'd like to know what the question is, or is he trying to keep Senator Padovan from speaking?
Senator Schermerhorn, Senator, you raised questions, and you asked that somebody answer them.
When's he going to ask the question?
He's answering the question, Senator.
Well, then I want to respond.
He is answering your question. You raised several questions, and you asked that somebody stand and respond.
I'm running down my notes from you.
Actually, then the other speakers did. I mean,
Senator, there is no rule in this chamber on how a senator may respond. Senator Gold has the floor.
Well, Senator, I can only say this, that what is that expression? There's none are so blind as those who refuse to see. I can't make anybody understand what I'm saying, and if I'm not saying it clearly, then I apologize to the point of view that I'm expressing. Maybe I'm not doing it justice. But, Senator, you also made reference to an endorsement. Well, I have a sheet or two I'd love you to read, but you mentioned lesbian women. I think lesbians. I think you also ought to know that the Church Women United have endorsed this, and also that the New York State chapter of National Assembly of Women Religious, I think that's a nuns group, have endorsed this. The New York State Council of Churches have endorsed this. And there are, by the way, Senator Gallagher, a number of groups listed here of black women and black men and others who apparently spoke in the only way they can, I will admit to that, and that is by communicating their views to us by written communication. Senator Skimmerhorn, you talked about political arm twisting. I hate to use that terrible expression about whose ox is being gored, but it seems to me it's either political arm twisting if they don't agree with you, but if they do agree with you when they're going around, that's just good old logic and wisdom that they're transferring. Before I answer your last question, I want to make this comment. You talk about scared of competition, you know. I got to say this, I guess, a little with tongue-in-cheek, but I think every male chauvinist here ought to vote for this law. I mean, enough of this business of women hiding behind these protective laws. Let's get them out in the open and beat them fair and square. And lastly, and very seriously, you talk about rushing into something. The point has been made over and over that this fight in New York State for equality of rights for both sexes goes back to 1923, and that's not exactly rushing. And on the other side of this building is an assemblywoman by the name of Rosemary Gunning, who I don't always agree with, and I don't think you're going to call her a raving liberal. But she talks about this fight going on for 200 years. And if that's rushing, Senator, then I don't understand those words. I think this amendment in its original form without the Eckert Amendment is long overdue, and I hope we pass it.
Senator Patterson, what is it, Senator Garcia? Your point of order?
Madam President, I'd just like to state that are we speaking only to the amendments or to the bill?
That's correct, Senator. To the amendment.
Well, Madam President, I'd like to get a ruling from yourself and from the leaders. Frankly, I have to leave, and I'd like to leave my vote. And I don't know what the procedure is in terms of leaving a vote when we're debating an amendment on the true bill. And,
Senator Garcia, the question came earlier with regard to Senator Mason's having to leave. I'm certain that the same courtesy could be extended to you to vote on the amendment, but it is impossible at this point to tell how to vote on the main resolution since no one can determine the outcome of the amendment. Senator Gallagher, what is your point of order?
Madam President, it's my understanding that both amendments are here on the floor. They've been called up. May I respectfully suggest that I think the rules would cover where if both of them are called at the present time, that with consent, Senator Garcia could in fact vote.
Senator Gallagher, if Senator Eckert's amendment prevails, then there is no main motion. Senator
Madam President, I inquired from you a little while ago about the number of speakers who have, number of senators who have asked to speak. And what I would suggest is that those who have been given the privilege of speaking to this amendment, if they can be as short as possible, because we would run out of the legal a lot of time. Now, we try to be relaxed about this thing so we can have a thorough hearing, but I would ask those people to try to cut it short if they can, because we still have to get to the main bill.
Senator Conklin, your point is well taken. I'm certain that the members will respond to that affirmatively. Senator Padovan has the floor.
Thank you, Madam President. I would like very much, if I had my choice, to vote for the Equal Rights Amendment, because I feel that perhaps the symbolism that it represents without an amendment is something that psychologically is needed perhaps today. And I recognize in this state and perhaps throughout the nation, there are many movements, many influences, which in their own fashion feel that this ERA, whether it be federal or state, is something that is sorely needed. And so that if I could honor symbolically that desire without any concomitant problems, I would be happy to do so. But unfortunately, that is just simply not the case. Now, Senator Gold said that people have a right. They have a right to express their feelings in the ballot box on this issue or any other issue. And indeed, he's correct. But they also have another right. They have a right to elect people who, before they present before them a constitutional amendment of this magnitude, that the legislators themselves fully, completely, honestly, and what that amendment portends for the present and the future. And if there's anything we can all agree on, it's a simple fact that we don't agree on what it portends. And even Senator Burstein admitted in the hearings held by the Committee on Judiciary, and here again today, that there were large bodies of law that would require substantial redrafting and enactment. She said there were 200, 100 perhaps cosmetically, and the other 100 substantively. Whether it's 100, 200, 300, or 700, we do agree that this legislative body, and indeed the courts, will be very actively engaged of putting bandages on statutes and bodies of law that exist in this state and have been achieved and arrived at over a period of many decades. And I wonder if that is the wise thing to do at this point in time. Now, in support of the amendment, we provide an opportunity of acceding to the desires of the feminist movements and the other groups, and at the same time providing protection where protection is required. Now, we've spoken in a very general sense about this, and just for a moment I'd like to be specific. A list of 227 laws in that state which would be affected. In the following session of that legislative body, 83 laws were introduced as a direct result of that amendment. Some of them, I have the numbers of those bills, dealing in the area of equality and family support, a bill to make a wife liable for her husband's debts, just as a husband is liable for his wife's debts. No provision was made to exempt a wife from her husband's debts, even if he had deserted her, or if she had children to support. A bill had to be introduced to delete the protection that existed in that state of a wife's property from being seized in payment for the debts of her husband. The bill was introduced, and this directly relates to some of the dialogue we heard earlier between our two senators. A bill to eliminate the right of female prisoners to have separate facilities in county jails, correction or detention houses. That is not my idea, Senator. It was a bill introduced in that legislature. You might disagree with its necessity. They did not. A bill was introduced to eliminate preferential life insurance premium rates. Again, this was something that was discussed before. The present law had permitted the rates of women to be calculated on the basis of 3 years of longer life. That provision had to be stricken. A bill to equalize the laws against forced prostitution. a bill to repeal certain protective labor legislation and equalize the compulsory work law. And on it went. I am very concerned about the fact that unless this amendment were to be tied in with this modification were to be tied in with the ERA amendment, that a whole score inter-family property rights would be laid aside, and that this body and the courts would be tied up for years to come in trying to unravel a mess, that is, if it could ever be unraveled. One of the real issues here today is not just simply the legal status of women. I think this state has perhaps been a leader, session after session, in enacting laws to provide for that equality. Last year, I think one of the most significant bills that passed and was signed into law dealt with the right to borrow money irrespective of marital status or sex. And I voted for that willingly, knowingly. It was a good bill. Just, I think, 2 weeks ago, Senator Dunn introduced a bill, it was last week, prohibiting discrimination against women in acquiring insurance because of their sex. These were good bodies of law, overdue perhaps. And we should continue to do that. We should continue to search out those areas where equality does not exist in the manner that it should. And since we live in a changing world, in a changing time, that process should be unending. But when we do it, we'll know what we're doing, and we'll know precisely the law we're dealing with. And in so doing, we will ensure the integrity of the legislative process. That integrity must also be protected. And when we talk about the rights of the voters, that is their right to expect of us that we will know what we're doing and not blatantly throw out like a deck of cards, and see which end they turn up or down. Last week, Senator Burstein, on another bit of legislation, you made the following statement, wherever you are. Oh, there you are. You said, "I don't think that under the laws of the state of New York that it is appropriate to pass laws that are precatory. I don't think that our laws should be expressing wishes. I don't think that you indulge the majesty of the law and subject people to penalties of whatever kind when you know that it is only expected that they will thereafter have their behavior modified. I think there are ways for the state to express this will. I think we can pass resolutions. I think we can fund studies. I think we can engage in advertising campaigns. But I think it's improper at a time when we already have grave disrespect for the law to be enacting another statute which cannot be enforced easily and which will lend itself to abuse. And for that reason, and having paid due attention to the arguments of Senator Kammerer, I vote no." I think you made a very valid point, a point that is applicable here. And I wish you'd made that same statement today. We are buying a pig in the poke. And it wouldn't be so bad if the results were not going to be so disastrous. There isn't one person in this chamber or in the other house, one judge, one body of men or women who can tell me directly so that I in turn can tell my constituents what this amendment, without the modification proposed by Senator Eckert, will do. Questions of marital support that I've touched on, industrial employment. Senator Gold indicated earlier that those labor laws which have been wisely enacted are designed to hold back women from employment. I disagree with that. My wife works. She's a nurse in a city hospital. Some man went in there, took the same job, got more money. I'd be down there yelling. She wouldn't have to. Some guy got promoted ahead of her, same qualifications. I'd be there screaming because those things would be wrong. But we already have laws in the state of New York to protect that eventuality. Just 3 weeks ago, the Commissioner of Human Rights in the city of New York took a large restaurant chain in the court under existing law. A woman had been discriminated against in terms of advancement. And not only was that corrected, but the woman received $6,000 in damages. She was sustained. So therefore we can say, certainly with a certain degree of conviction, that we have not been holding back. This does not mean that we should not be progressive in moving forward. But again, I repeat, when we do it, let us know what we're doing. There are certain jobs that men do which are dangerous, which require physical capability that exceeds the average capability of a woman, and they're paid for it. And if a woman can do that, let her. But the laws in this state protect her from having to, and I think those laws are intelligent. And I see no reason to lay them aside, as I believe this amendment would do. Should it pass in its present form, and such labor laws be tested in court. We seem to be ignoring the fact that under the Constitution of the United States, I think someone mentioned it earlier, 14th Amendment, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Are we forgetting about that? Are we making believe it doesn't exist? The women in my district are typically married women with children, many of whom are out working to help support their families, help make ends meet. And they've asked me what this is all about. And I've told them what I know, and I've told them what I don't know. And they are expressing their concern. I question very seriously whether some of the groups you have cited, Senator Gold, truly represent cross-section the women of the state. Tonight, if this amendment passes, there'll be parties in some of the better places in town, some of the finer country clubs, hosted by feminist organizations who will hold this up to be a new emancipation proclamation, a new breakout. Great thing that's happened. But there will be other women in their homes, tending the needs of their family, who will wonder, quite seriously, as to what we have wrought upon them. And I ask you to wonder with them. And the least we can do is adopt this amendment to protect them in the manner they should be.
Madam President. Madam President, today we're so taken with the apparent righteousness of this principle of equal rights that we've become dazzled by the forest it presents. And in fact, because of that forest, we're failing to notice if any trees are falling on real people. I voted for ratification of the Federal Equal Rights Amendment, and I recall the debate on that, and I recall hearing Senator Schermerhorn speak about the draft and about Social Security at that time, and there was a giggle through the room. Forgive me, Senator, but we all thought you were crazy. Now, we're listening to you, and we're seeing our troubles in other states where they consider the same problems you brought up at that time. I voted for the state ERA the first time around. I submit to you that now that the first flush of emotion is over, and we're moving to more real concerns, more concrete concerns, We're away from the personal political problems that some of us may have, and we're looking towards the real hardships that real people who are living today may face. My doubts about the Equal Rights Amendment are its sweeping approach, this broad-based meat-axe approach, if you will, which even if sound in principle, may work hardships in very many individual cases. The difficulty with the constitutional amendment is that if unexpected harm comes to the surface, if there be some area of the law that we're not aware of today, if there be something in those 100 bills that Senator Burstein mentioned that needs correction, we may not be able to do anything about it in the legislature. We may have given our prerogatives up to the courts. Injured parties, of course, if they have the means, and only in that case, will pursue their remedies before a judge. People who have lived most of their lives prior to this change have made life choices. They've adopted lifestyles. And they may become victims of a legal transition that they've never anticipated. I don't think sufficient effort has been devoted towards gauging the effects of a constitutional amendment with regard to its particular effects. How does it affect individuals in our society? I ask you, and I ask those who speak in behalf of the amendment, the main amendment, what are the injustices we seek to correct by adoption of the ERA? What areas of sexual discrimination have not already been declared unconstitutional by the Supreme Court? Does the amendment not, in effect, serve to eliminate all legal distinction between men and women? What lines are affected in our state by such a general transition? What are those 100 bills? I ask you, do we not have a moral obligation to determine what wrongs we seek to correct and to look ahead today to see who the victims are, if any? And if there be any, would it be more rational to proceed in a more orderly and deliberate fashion? To say this is an issue to be decided by the people and therefore we should adopt the amendment today does not actually say that we didn't in the past adopt other issues of a very great moral impact, of great dramatic moral overtones, without benefit of public referendum? If we were to turn this down today and say, no, we're not going to let the people decide because we have too many questions in our own mind, would it be any departure from what we've done in the past? The fact that there are grave doubts in the area of equal rights amendments is made apparent by the difficulty in obtaining the passage of the Federal Amendment. All the ramifications of ERA are not known today, and I ask you, will any state laws be affected that deal with support, custody, employment? Is there any adverse impact on the social benefits of older women, widows? I have a great many senior citizens, widowed women in my district. How will it be affected? In eliminating the distinction between men and women, does it mean that where a woman gets a greater benefit today, that benefit will be reduced, or that the benefit to her male counterpart will be increased? Senator Burstein said, we'll increase the widowers. Well, I ask you, Can we do it? What is the cost, or is there a cost involved to the various levels of government? If some judge says we must, can we? I submit that with enforcement of the Supreme Court rulings and existing laws which prohibit sexual discrimination, much of the argument for this amendment would cease. While I agree that any discriminatory practices which act contrary to the rights of women should be eliminated, I am fearful that not knowing what can happen is the worst of what is attempted today. We mentioned homosexual marriages and various other things, but I've read some of the material that's come across my desk. Some of it indicated that the marriage of homosexuals is permitted in Colorado after the adoption of an Equal Rights Amendment. I've heard a radio newscast in which it was stated that male and female high school students are permitted to engage in contact sports, namely wrestling, in the state of Pennsylvania as a result of the ERA. You may be for or against wrestling between boys and girls. That's your personal opinion. But the fact of the matter is that when girls went to join the wrestling team in the state of Pennsylvania in the high schools, the school board and the school officials turned them down. They never contemplated such a thing within their schools. But when the appeals were made to the court said under the ERA that it is improper to impose any segregation between boys and girls with regard to their sport activities. Senator Torriello points out to me that the next day 500 boys joined the wrestling team. I don't think that's what we're contemplating today, but could it happen? I don't know. There's a letter floating around that's come across your desks as well as mine from a state senator in the state of Washington, where he points out that the Equal Rights Amendment adopted in 1972 made it unconstitutional in the state of Washington to segregate students by sexes even in individual living quarters. Is that the case? Will that be the case here? Will the deans of our colleges be unable to have male and female dorms or rooms or whatever? I don't know. But I say because I don't know, because I don't have the answer to too many questions, that perhaps I would be better advised to defer taking any action today. Let's get the reports of the law revision committees. Let's find out where we're going, and then decide whether we want to go there or not. With regard to the amendment offered by Senator Eckert, it states in there that this amendment shall not apply in cases where in cases of classification where there's a compelling justification. I believe that's more or less the language. I don't know what that means either. I don't know what that means. And I think that could very well go to court just as the main amendment could go to court. I know that consistency is considered a hobgoblin of the mind, and I don't want to be in that category, but I'm going to be consistent on this. I'm going to vote no on the Eckert Amendment, and then I'm going to follow that up with a no on the main amendment. I would urge you to do the same. Okay.
Madam President.
Madam President, I understand that we have bylaws by which the decorum of this chamber are run. We've got enough. I, for one, I'm sorry, I'm sick, and I'd like to vote on this amendment and get my vote in on the amendment, and I'm staying here and waiting. People are getting up on this amendment and making statements about the main amendment. I wonder if those people would just allow me, please, to have this amendment over with, and if you're going to make a general statement on the amendment put before us, give me an opportunity to be able to leave because I'm not feeling well. Everyone's talking about the Eckert Amendment and the main amendment. I think if you would do that, if you want, then Madam President, we have rules, and I don't know who suspended the rules of the 2-hour debate. It certainly wasn't done in the proper manner. I'm not raising that point at this time, but I think we ought to at least get rid of this amendment if it's going to be on if it's going to prevail. Let's know about it, and then we can all talk about the amendment. Maybe I could be allowed to vote and leave.
Senator, for the record, just a moment, Senator Bernstein. For the record, the majority leader and the minority leader informed the chair that there would be a suspension of the 2-hour debate, Senator Lewis, because of the importance of the amendment, and there was no way to contain the debate within 2 hours. There are on the list, speaking on the Eckert Amendment, Senators Markey, Perry, Nolan, and McFarland at this time. And then the chair has a list of several speakers who wish to speak on the main amendment. Now, if any senator who is on the list to speak on the Eckert Amendment wishes to have the opportunity to speak on the main bill and will give up the right to be able to be heard on the Eckert Amendment, the chair will so honor that. Senator Markey, would you like to speak to the amendment? You have the floor. Yes, Senator Bernstein.
I would just like the record to indicate that I join in the request made by Senator Lewis. I, too, because of certain swelling in my foot, have to go back to New York today, and I would like to have the opportunity to vote on both amendments.
The chair can simply ask the members whose names have been called whether they would be willing to speak to the amendment, to the main resolution instead of the amendment. Senator Nolan?
I'll be willing to speak to the main amendment instead of...
Senator Perry, will you? All right. Senator McFarland, you wish to speak to the amendment? All right. Senator Markey, you have the floor. Senator Lewis.
I don't believe that the rules of this House allow minority and majority leader to make a rule binding on all of us. And therefore, with all due respect to your ruling, there is no bylaw now that has suspended the rules of this House.
Madam President, if I may explain. Senator Lewis is quite correct. Neither the majority nor the minority leader, separately or together, may suspend a rule. What we agreed was that in view of the importance of this matter, and as has happened in many other occasions, we had asked people not to call the rule. If someone wishes to call the rule, the rules require that debate may be suspended after 2 hours. It is not mandatory. There would have to be a vote taken as to whether to suspend debate.
The chair has the language of the amendment, and it says that it would be in order for any senator to move to close debate, at which time that would come to a vote. And that would be the procedure to follow should any senator wish to invoke it.
Therefore, there is no suspension of the rule. It was simply a question, since we have on many other occasions gone way beyond this time limit, and neither side or people have not called time, we have urged people not to do that. If, however, anyone wishes to do that, they may. However, I do join with Senators Lewis and Bernstein that this has been a long day, and this is a matter of importance. If we can begin to come to grips with the end of this debate on this amendment and then come to grips with the main bill, I think it would be in the interest of the body so that everyone can vote, which is, after all, the most important part of this aspect, so that everyone can get their vote recorded. It would be the interest of everyone concerned if we could hold debate down and come to a conclusion.
Senator Markey.
Under these, close debate.
The motion is not debatable. Senator Lewis has moved to close debate.
On the amendment.
On the amendment, or
Yes, on the amendment.
Close debate on the amendment. Actually, it's to close debate, period, because the amendment and the debate, if one is to invoke the rule, is a 2-hour limitation.
Madam President, I think I have the right to make a responsible rule definitive to the particular matter before us. I move at this time to close debate on the Eckert Amendment.
Senator Lewis moves to close debate on the Eckert Amendment. Senator Anderson, it's not debatable
I
motion.
didn't quite understand the chair's ruling with reference to whether this would close debate on the
No,
main
just on the
bill.
Eckert Amendment,
Just
Senator.
on the amendment.
Secretary will call the roll.
Anderson, Bloom, Conkle, Markey, Ormston, Water, Winneco.
So on the amendment, it's got to be no.
The chair will clarify An affirmative vote is a vote to close debate. Negative vote is a vote to permit the debate to continue. Senator Lewis, if the chamber would establish order, the chair will repeat. Senator Lewis has moved to close debate. An affirmative vote is a vote to close debate on the Eckert Amendment. A negative vote is a vote to permit the debate to continue on the Eckert Amendment. No, he should be. He's voting right.
Madam President, if one on this vote raises his or her hand, does that mean that the Eckert debate is closed if you raise your hand?
I will repeat. An affirmative vote closes debate on the Eckert Amendment. And if you raise your hand, you are saying no, you wish the debate to continue on the Eckert Amendment.
Thank you, Madam.
How long are we going to go on this thing? 2.5 hours on the goddamn amendment. Everybody's talking about the main amendment.
Madam President, would you again clarify the significance of an affirmative vote?
Senator Levy, once again, will this House establish some order? Senator Levy has asked for further clarification. Senator Lewis's motion is to close debate. If you vote to close debate on the Eckert Amendment, you are voting yes to close debate. If you are voting no and raising your hands or saying no or in some other fashion expressing a negative vote, that means that you are prepared to have the debate continue on the Eckert Amendment. Senator Marino.
Madam President, I'd like to ask if
Yes, Senator.
You and I have been wrong before, but this first time we've both been wrong at the same time. Under the new rules on page 20, Section 3, Subdivision C, the new rule says when any bill, I'll skip a couple, shall have been under consideration for 2 hours, including all amendments, it shall be in order for any senator to move to close debate. So that your initial reaction that
To close the whole
you
thing.
changed your mind on and I changed it with you was wrong. Actually, the motion that's been made would close debate not only on the Eckert Amendment but on the bill
Senator,
itself.
that was what the chair believed the rule to be. Senator Lewis then stood and said he wanted to be reasonable and attempt to close debate only on the Eckert Amendment. So that was what he amended
I
his
see,
motion.
not subject to the rule. He was just making a motion general.
He limited his motion, and that was why the chair responded. Senator Marino.
Madam President, I just want to inquire whether it would be possible to amend Senator Lewis's motion.
No, Senator, it's not amendable nor debatable.
It is not. Would it be permissible to amend it so as to include closing statements on both sides?
Senator, it is not amendable. If after the vote is taken on this amendment, another amendment. Senator Marino, do you wish to make a motion at this time? Senator Markey, you have the floor.
Well, Madam President, after this auspicious introduction, I am almost tempted to deny you the wisdom of my thinking here, but Senator Lewis, I'm sure, was trying to protect me from the errors of my folly of my ways, but I will be brief in deference to the concerns that he expressed. This has been a very perplexing problem, Madam President, because constitutional amendments are resorted to in the absence of constitutional provisions which make it impossible for us to meet problems where there is no recourse other than to change the Constitution, either to extend a protection or to provide a limitation or to alter the institution of government. And absent this, there is the usual question that where we pass on to the judgment of the greater public matters of constitutional import should only be resorted to, in my view, where there are no legislative procedures available or action that is amenable to the resolution of important public issues. And where they exist and they are in place, of course, then it is not merely a question of interposing ourselves between an important fundamental change in state policy as is expressed in the Constitution and the public, because we have the opportunity really under the existing Constitution to tackle certain problems. So that I feel that certain questions should be answered before we can properly respond, and Senator Eckert's amendment does raise one of these considerations. Under Section 11 of the Equal Protection Laws, it stated that no person shall be denied the equal protection of the laws of this state or any subdivision thereof. No person shall, because of race, color, creed, or religion, be subjected to any discrimination in, and here they use the word his, civil rights by any other person or by firm, corporation, or institution, or by the state or any agency or subdivision of the state. I would assume that if the word sex would have been desirable as an extension of the equal protection of the laws, that it might have been inserted here, but it was not, and it was presented as a separate amendment as Section 13 of Article 1. However, in speaking to it, we've had various applications. The State Athletic Commission in 1968, for instance, ruled against granting of wrestling licenses to female wrestlers, that this was not an unjust and unconstitutional discrimination against women. I don't know what, it was an appellate division holding. I don't know what the holding would be today. In 1962, the court held that if any policewoman can properly perform enough functions of command and administration which male sergeants in New York City Police Department should be able to perform or to warrant her promotion to rank of sergeant, prohibiting promotion of any policewoman to rank of sergeant must be held unconstitutional on the grounds that statutory classification on basis of sex is arbitrary and capricious. And more recently, of course, on the question of sex, there were tests given to candidates for civil service employment as audiovisual aid technicians, and they gave them extraordinary weightlifting tests with barbells and disqualified some of the women. 43 persons took the test, 41 men passed, and both of the two women failed. And the court held at that time that legislative classifications may legitimately take account of need or ability, but may not be premised on unalterable sex characteristics that bear no necessary relationship to individuals' need, ability, or life station. Legislative power to make classification based on sex should not be applied mechanically without regard to the reasonableness of the relationship. So that what it would seemingly be indicated is that we do not have unavailable, there is not available recourse to constitutional law in interpreting that which is before us. As a matter of fact, the new section that is proposed speaks to the denial or abridgment by the state of New York or any subdivision. Section 11, of course, also addresses itself to categories other than political subdivisions in the state of New York. So that we have to determine whether, I think there's been a lot of hyperbole on both sides, Madam President. I don't believe that if we ever had the Equal Rights Amendment on the law, that, and I had some concerns which were allayed by Senator Burstein and others, that the affirmative action aspects were not quite what some of us perhaps might have thought about initially. Nevertheless, I think that there are two things. Is there an absence, or is there a void now in the existing constitutional protection which precludes legislative responses and resolutions to important public policies? And two, is our policy now prejudicial or in any way restrictive of our ability to address ourselves to these problems? And Senator Eckert, of course, raises the very reasonable concern which we may have, and perhaps this may be answered, and I think this would be very, would certainly be persuasive with me. We go into the executive law, for instance, section 296. Nothing in this subdivision shall be construed to prevent the barring of any person because of sex of such person from places of public accommodations, resort, or amusement, if the division grants an exemption based on bona fide considerations of public policy, which seems to be Senator Eckert's, the thrust of his amendment. I don't know whether it realizes this completely, but it's the only amendment we have before us that seems to take into concern these bona fide considerations of public policy. Nor shall this subdivision apply to the rental of rooms in a housing accommodation which restricts such rental to individuals of one sex. I just don't know how this cat is belled by what is being proposed. What happens to 296, for instance, as it applies here? And it's a very erratic article because sometimes it speaks of sex, sometimes it does not. But it may suggest that under existing constitutional provisions, we have indeed available to us all that is necessary to meet problems, along with an ability to accommodate considerations of public policy, such as the example I've just cited, in a reasonable way without depriving the men and women of this state of the equal protections of the law and the equality of rights as it is expressed here, which should not be denied. We go into insurance, of course, experience rating with young women drivers and young men, and some of the arbitrary classifications which are amenable certainly to statutory change, and I think there's been a great propensity to recognize these wherever they exist. But I think that question has to be answered specifically with respect to the Eckert Amendment. What happens when we have considerations of public policy involving a consideration of sex, which does not really touch, I don't think, the question of our right to equality under the law and our right not to have our rights abridged by any laws enacted into law by the state or the political subdivisions of the state. I think it would be very helpful if the proponents of the main amendment, unencumbered by the Eckert Amendment, speak to this before we can properly make a decision on the amendment itself.
Senator Perry.
Mr. President, I would like to have the opportunity to speak against my colleague from Monroe County on the Eckert Rider or the Eckert Amendment to demonstrate at least that there's more than one voice from upstate New York, and I would hope that the voice from the east side of Monroe County is a little more progressive than what is demonstrated in the Eckert Rider. There have been many issues discussed today, many of them very technical and legal questions, but I would like to take the discussion a little bit differently, in my belief that those who support and oppose the Eckert Rider or the ERA really are looking upon the role of sexes in society in a different manner, and they have constructed their outlook toward the role of the sexes on their understanding of history. Now, the unfortunate point about this that it is very difficult to get an accurate view of history for anybody, because we are always subject, when we are looking at the history of the world or the history of the sexes, we are looking at the frame of reference of the author, we're looking at our own frame of reference, and quite often these two frames of reference reinforce themselves, and we get very confused and possibly end up with a completely distorted picture of what is reality. The point is that most of the history of the world has been written about by males and about males, and in that sense it's suspect when we are talking about the role of the sexes. I only point this out because my views on this topic have changed considerably over the last decade. I don't believe that anybody can, maybe you can speak for other people, but I do not think that you can really understand other people unless you listen and hear their point of view. And if you haven't read feminist literature, feminist history, then I really think that you would have a prejudiced view, quote unquote, on this particular topic. It's just as presumptuous on this issue as it is for people to speak about black slavery if they do not really understand the point of view of the slaves, or to speak about the history of any society or any culture without really understanding the people of that particular culture. The point I'm making is that the people who are opposed to the ERA and favoring Senator Eckert's amendment really, I think, are looking at this from a one-sided, narrow point of view. I think it's essential that the ERA get passed. It's not innocuous. It's important. It's important that the public policy of this state be clearly stated that there will be no discrimination based on sex and that there will be no special privileges granted because of sex. Senator Eckert has made the argument that we should not have a constitutional amendment, and instead we should deal piecemeal with each part of this legislation. I do not think Senator Eckert's argument can stand the test of reason. We are dealing here with basic human rights, and as far as I'm concerned, when we are dealing with such basic human rights, they should be absolute. If Senator Eckert's logic was followed, we could repeal the whole Bill of Rights of the Constitution and deal with each and every one of these on an individual basis. Senator Schermerhorn talked of the conservative philosophy and the fact that the Conservative Party supports this amendment, and I know that Senator Eckert has been closely associated with the Conservative Party and the conservative philosophy. I say to you, gentlemen, that I don't think that conservatives understand their roots, their philosophical roots, that is based in the classical liberalism of the 19th and the 18th century. Because at least if they understood it or acknowledged it, they would believe in the individual rights of people, and they would be supporting the ERA and not being opposed to the ERA. Now, there are some people who classify themselves as conservatives who aren't really conservatives but are traditionalists. And they are worried about the ERA upsetting their traditions. I don't want to upset their traditions, and I don't think anybody here wants to upset their traditions. And I don't believe that there is anything in the ERA that will destroy their traditions. They will continue to be able to live as they have lived in the past. What bothers me most, and what bothers me particularly because this Eckert amendment to the amendment was not offered last year, is that I see a certain opportunism here, a certain opportunism that feeds on the fears that have been raised by various groups, and that these people are really acting sorry, Senator Lewis, but I must point out what the real source of the support of this type of amendment is, and that these people are really acting out of fear, and it's this type of demagoguery that I think must be defeated in defeating the Eckert Rider.
Senator McFarland.
Thank you, Madam President.
Oh, come on now.
Mr. President.
Thank you. Thank you very much.
President first. Habits are tough to change, Mr. President. It's nice to see you up there. I think this is a completely salutary amendment. Senator Gold, I suggested if we had trotted out this Equal Rights Amendment with this language attached, I think you could have persuaded me to vote for it. And I think you would have voted for it. And I'll tell you why. You gave an electrifying demonstration of your grasp of all the statutes in this state, which are really violative of the broad brush anti-discrimination statute we passed, because we've respected the need to have some classifications which were reasonable. And all the Eckert Amendment does is it says that if you've got compelling justification, you can continue to provide such classifications. I think not yet. I think that's very salutary, and I think that we should adopt this language, because otherwise we're going to have the courts having a field day in this area of discrimination based on sex. They're going to be legislating by judicial fiat. It's either going to be a field day for them or a nightmare. In any event, let me point out to you that if we had this language, we would really be doing a favor for a lot of the widows of retired teachers in this state. In 1966, we passed, we submitted to the public, and they approved Constitutional Amendment, Article 7, Section 8, which allowed the legislature to increase the pension of a widow of a retired teacher. And that seemed to be a classification based on gender, which had a compelling justification. Now, we then passed legislation in support of that amendment, and now there are thousands of widows of teachers throughout this state now getting supplemental pension benefits. And if you pass this main amendment, without the language here, which is very salutary and helpful, automatically you're going to deny those widows of the supplemental pension benefits by the passage of this law. Now, I don't know how many there are. I've tried to find out. It's difficult, but there's got to be thousands. Now, there's 1,000 votes against the main amendment out of their own self-interest. Now, do we really want to take the supplemental pension benefits away from widows? That's what we're going to do. Now, the legislation we passed is annual, so you can't say that it's something frozen into the law as a pension, which another section of our Constitution says cannot be diminished or impaired, because it isn't a permanent benefit. It's only temporary. So now you tell us what we should do is we should give these widows pensions, or widowers pensions. Well, you can't do that unless you have another constitutional amendment. So, really, this is one area where I can tell you with certainty what's going to happen. No doubts, no guesses, no rub-in. We need the Eckert Amendment here, as it's been called. I think it should be the amendment of all of us, and I commend it to you. And I think that if we pass this, then we can go on in the next election, pass a proper piece of legislation, and we can spare the public, courts, ourselves of the harm and the mischief that the main amendment, unabridged by the Eckert proposal, would be sure to give us.
Senator McFarland, will you yield to Senator Bonston?
I certainly will, Mr. President.
Senator Bonston.
Senator, what you've said is an argument that I might accept from anybody except from a lawyer, and a lawyer whose judgment I respect. Now, Senator, what language in the Eckert Amendment can possibly apply to the situation that you adduce, or can possibly be utilized in constitutional language? Where have you ever seen language like this that could be applied by a court reasonably to a situation created by the passage of the amendment itself?
We've passed some legislation which is broad and sweeping, to be sure, and a constitutional amendment is supposed to be not a piecemeal kind of thing, but a rather broad presentation of guidelines. And as Senator Gold has pointed out, the courts haven't been very strict in enforcing some of the tough anti-discrimination laws we've passed, because they recognize, even without this kind of salutary language, that there is a need, compelling justification to allow these classifications to persist. And I say that the language of the proposal itself would give a court our endorsement and our inspiration and incentive to continue to allow classifications to persist where they're reasonable and where there is justification for them.
Madam President.
Senator Donovan.
Madam President, I'll be brief. The hour's late, and I want to say a few words on the amendment. We had earlier assurances from the sponsor of the main amendment that that which they addressed themselves to with great certitude would relieve any doubts that any of us might have as to the effect of the amendment. And that they didn't say in their opinion, the dialogue was precisely what it would do and would not do. Well, as I understand it, only the judges in the courts will decide what this amendment means and what the intent of the resolution truly might be. And so what we say here will have little bearing, in my opinion, on what the judges ultimately decide this year, 10 years from now, 20 years from now, or whatever. The amendment undoubtedly will go to the voters this fall, very likely without the Eckert Amendment. Now, there have been those who have criticized Senator Eckert for proposing the amendment and bringing it on the floor in the manner which he did and speaking to it with the great conviction and sincerity that he has evidenced here today. That's his privilege. Not unlike the privileges of members of the Congress of the United States, where they too proposed 4 amendments prior to the final adoption of the companion resolution that we're talking about here today. My point in terms of the amendment that Senator Eckert has offered is this, that I think that come next November, after the election, the wisdom of what Senator Eckert is doing here today will be borne out. Because in my opinion, based on the polls I've taken within my central New York region, leads me to believe that the people of the state do not understand what this amendment's all about. 71% of the people who responded to my questionnaire on this amendment, and there was over 10,000 that responded, either were opposed or didn't understand the amendment. And that's after considerable publicity on the federal amendment and last year's passage of this amendment. My point is this, Madam President, that in my opinion, without the Eckert Amendment, the ERA resolution as it will appear on the ballot this fall is doomed to defeat, because the people are fearful of what this amendment embodies, and when in doubt, they won't do it. And they're in a negative frame of mind, and they're far from convinced of the propriety of this resolution at this time, particularly when the federal amendment's in such deep trouble, maybe to the point that, much like the Child Labor Act of 1924, where it swept across the country, that was 50 years ago, and then suddenly stopped after 24 states ratified it, and never was to be heard from again. I think we're doing a disservice to the ERA amendment by rushing into what we're talking about here today. If we're going to truly put together an amendment for equality for all sexes, both sexes, then I think we should take the issue to the people and tell them precisely what it is that is going to be affected by the amendment. What laws are going to be changed? What effects are going to have on lifestyle? Educate the public so you get a knowledgeable electorate and they will do the right thing. We are rushing this out to the ballot because, in my opinion, the proponents are fearful. They see the attitude and the trend of the country, that the people are saying, wait, halt, stop. This is enough. And I think that attitude is going to carry over to November. I think it's going to be intensified. And without the Eckert Amendment attached to this, it's my opinion that this whole effort, as laudable as it might be, in its purest form, is doomed to failure. I said earlier that the courts will look to the legislative intent. The courts will obviously determine that the Eckert Amendment failed, that this legislature in their wisdom said no. And the courts will say this legislature, by a majority vote, rejected the impact of the Eckert Amendment, so therefore there is no legislative intent to provide some differentiation in terms of physiological differences or compelling reasons. And the courts will have carte blanche as it relates to the laws that are in the books now and any future laws that we might want to consider here in the New York State Legislature. And that will be the case for as long as this amendment is on.
Senator Donovan, would you suffer an interruption? Sure. Would this House please establish some order? The conversation is escalating and Senator Donovan can hardly be heard. It's hardly showing a member of this body the respect that he's deserving at this time. Senator Donovan.
Thank you, Madam President. In the interim, I lost my thought. But suffice it to say, Madam President, that the courts will look upon the intent that's being expressed here today. And in that regard, the courts can act in any manner that they see fit as it relates to the ruling in this constitutional amendment. And that amendment will take precedent over any other decisions that they may have handed down. So much of the rhetoric that came from that side of the aisle, in terms of what the impact will be, they don't know. Nobody knows. Only the judges know. And we may or may not be electing them. But those of us who are elected by the people to stand in this chamber to make the laws of the state as it affects people of the state, their lifestyles, and all other aspects of human behavior, we will be precluded from doing anything that might be contrary to the impact of this amendment. Then after the amendment is defeated in November, we will come back here, and as a mandate of the people, we will be expected to rescind the federal ERA amendment that we passed a couple years ago. That will be the message of the people, and so the whole federal effort will be set back, as well as the defeat of the state amendment. That's my opinion. That's where I stand. I suggest to you that the wisdom of the Eckert Amendment will be borne out by the defeat of the ERA come November, and that man will be proven right, and his colleague from Monroe County will be proven wrong.
Madam President, I rise to close debate for this side, and I'll be very brief.
Senator, just a moment, please.
Senator Ornstein closing debate on the amendment?
On the amendment, Senator.
On the Eckert Amendment, not on the amendment itself. Madam President, a lot has been said on the substance of ERA and what is being attempted here. There is no time to detail the many errors and misstatements that have been made on that question. Suffice it to say that 15 states have passed this very amendment without the Eckert rider. And none of the effects which have been recounted here have taken place. To point just to one error of misstatement, Senator Padovan alluded to bills which were introduced in Maryland. Those bills were introduced, but were not passed. The courts have acted, and none of the effects which have been accounted have taken place. Suffice it to say that this very amendment, the ERA amendment, without the Eckert Amendment, was passed in the state of Utah in the year 1896, and that this same amendment was passed in the state of Wyoming in the year 1890. And none of the effects which have been recounted here have taken place. The Eckert Amendment stands, therefore, as a simple procedural effort to delay the constitutional process from proceeding to an end. We have a great history in this country in terms of the constitutional process. The Constitution of the United States, the Constitution of this state, when it talks in terms of rights, talks in terms of broad expressions of principles. And when those principles have been stated by the people under the broad constitutional mandate. And in this state, that process includes a vote by the people, not by the legislature, by the people for and against. And when those broad constitutional statements have been made, it was then the courts and the legislature which implemented those principles. We have stated that in this nation there shall be no prejudice on account of color. There shall be no discrimination in the law on account of national origin. There shall be no discrimination in the law on account of religion. And in none of these instances have either the courts or the legislatures acted unreasonably or irresponsibly to suppress or depress the rights of anybody else. And that is what is proposed in the ERA amendment, a broad principle prohibiting discrimination on the ground of sex, a broad declaration of principle on which the people ought to have the right to have their say. Senator Eckert's amendment would deny them that right, because under our process, this amendment stands ready today for final passage and for submission this November to the people. Senator Eckert's amendment would deny them that right. I know there are legitimate differences of opinion on the substance of the ERA amendment, and those opinions ought to be stated, and the people ought to have a right to state them. So a vote for the Eckert amendment denies the people that right. A vote against the Eckert amendment affirms the right of the people to decide the destiny of the state. I urge that this amendment be defeated, that we go on to debate the substance of the amendment, and then allow the people their will.
Senator Anderson, are you going to yield to Senator Eckert to close debate?
Yes. On what he says and not how he votes.
Senator Eckert.
Madam President, I want to be brief in closing because we have been at this considerably longer than perhaps we should have. But I repeat what I said at the beginning. I think it's fair to say that all of us agree with the rhetoric, but it's the nitty-gritty that we have to cope with, that we have to deal with, that we have to face. Again, a basic question. Just precisely what does a mandate banning the denial or abridgment of equality of rights under the law really mean? Does it mean that any classification must be justified by compelling reason? Or does it mean that there could be no distinction, no differentiation whatsoever? Discrimination means to make a distinction. This amendment that I've proposed merely states that there can be a reasonable differentiation when there's a compelling justification for doing so. Some of the advocates of ERA, while not throughout the entire course of the debate ever pointing to a single glaring abuse in the law that ought to require immediate action, they've said in effect, don't worry about the questions that have been raised because there would be a reasonable justification for them. It's precisely what I'm saying, that we ought to be sure that we incorporate into the amendment, into the language that we etch into the Constitution. Senator Gold referred to some silly classifications still on the books. But he's careful not to pretend that a court would likely rule that there was any compelling justification for any one of those silly classifications that he referred to. He was right to say that such silly, inequitable provisions ought to be repealed. And he was right to infer that it was negligent of us not to have corrected them up to this point. But I think he would have to concede that if people like myself were negligent in not doing so at this point, then certainly those in the legislature who have been here longer have been more negligent. There's been much discussion on whether or not, in fact, the equal protection provision of the 14th Amendment of the Constitution covers much of this area that we're talking about. Many have risen to say that that language says that no person shall be discriminated against on the basis of sex and creed and so on. And they take this to mean that therefore a woman should, because it says, it does not specifically say sex, but it says person. In my judgment, if I were a judge, and I'm not, it would seem to me that the word person includes both male and females. I think that's rather obvious. Senator Ornstein made an impassioned plea to let the people decide. Yesterday, Senator Ornstein, leading an attack against the McFarland Amendment, led a plea not to let the people decide. If we are to take the view that any constitutional amendment ought to be quickly passed through in the language of its initiator, then I think we ought to follow a consistent policy on that. We have not. I myself have introduced constitutional amendments that I feel are more significant to the people of this state than this particular one. In the areas of strong reform of initiative, referendum, recall, and I think more important for the financial future of this state, what I call a Fiscal Integrity Act to provide a taxing limitation program so that we can have a curb on the amount or the percentage of the wealth of the people that this state is going to take from them. I think that's the kind of substantive thing that people are concerned about, and not our deliberations over slogans. You can say, and obviously it is correct, that approval of this amendment would delay approval of an ERA bill proposal this year. But I think that if you are continuing, as I feel we are, going down, to not delay, in view of the indecision, of the inconclusiveness of the consequences, of the cloudiness that surrounds the entire issue, of the uncertainty that is so evident by the fact that it is so late in the evening now and we started so early, that the indecision seems to, about the consequences, continue, then I think that puts us in a position of continuing to go blindly down a path when we don't know where it leads. And I don't say you just continue for the sake of continuing. Senator Burstein, whose judgment I respect on many issues, has her interpretations of what the consequences would be, of how a judge would rule. Professor Freund, on whose judgment I have heavily relied, has precisely the opposite. Neither of them is a judge. And we are going to be handing to the judges language that they are going to have to interpret, and it seems to me that that language is presently framed in a way to preclude reasonable distinctions. I don't think that's sound. I think the amendment that I have proposed is a reasonable approach that would make crystal clear the state's position on discrimination, on fair discrimination, and I think that it would certainly block and be interpreted in the courts to block invidious classifications, but it would permit the legislature and the courts to make reasonable differentiations where there's a compelling justification for doing so. I think that's a sound approach, and I think to ignore that is to treat lightly the very serious business of amending the Constitution of this state. I move the adoption of my amendment and ask for a slow roll call.
Ring the bells. Question occurs on the amendment to the main resolution. Secretary will call the roll.
Mr. Anderson? Mr. Auer? Mr. Barkley? No. No. Mr. Beatty? Bellamy, Mr. Bernstein, Mr. Bloom, Mr. Bronston, Ms. Burstein, Mr. Kammerer, Mr. Calandra, Mr. Conklin, Mr. Donovan, Mr. Dunn, Mr. Eckert, Mr. Flynn, Mr. Gallagher, Mr. Garcia, Mr. Jafrida, Mr. Gold, Mr. Goodman, here he is, Mr. Gordon, Mr. Griffin, Mr. Halpern, Mr. Hudson, Mr. Isabella, Mr. Johnson, Mr. Knorr, Mr. Leitzer, Mr. Levy, Mr. Lewis, Mr. Lombardi, Mr. Markey, Mr. Marino, Mr. Mason recorded affirmatively earlier today. Mr. McCall, Mr. McFarland, Mr. Meyerson, Mr. Moore, Mr. Nolan, Mr. Ornstein, Mr. Owens, Mr. Padovan,
Yes.
Mr. Patterson,
No?
no. Mr. Perry, Mr. Pisani, Mr. President, Mr. Rollison, Mr. Ruiz, Mr. Santucci, Mr. Skimmerhorn, Mr. B.C. Smith, Mr. W.T. Smith, Mr. Stafford, excused. Mr. Conklin?
No.
No. No.
No.
Let's finish the
No.
roll call and then do the absentees, huh?
Mr. Straub? Mr. Torriello? Mr. Trunzo? Mr. Volker? Mr. Warder? Ms. Winico? Absentees. Mr. Gallagher? Mr. Flynn?
Announce the results.
Ayes 16, nays 42.
The amendment is defeated. Senator Anderson.
Before we get